My name's Keith Fox, and I'm a lawyer at Victoria Legal Aid and part of the Your Story team. Firstly, I'd like to acknowledge the traditional owners of the land we're meeting on today, and I acknowledge that I live and work on the stolen lands of the Dja Dja Wurrung people, and I pay my respects to their elders past and present, and to the Aboriginal elders of other communities who may be here today. So today we're going to have some presentations from Your Story lawyers. And firstly, I'll do a bit of housekeeping. This webinar is being recorded as well as live streamed to the Your Story Disability Legal Support page. Auslan and captions are available. So to turn on the captions, go to the toolbar at the bottom of your screen and click on the bottom the button labelled CC Live Transcript. Then you can select Show Captions. Please post in the chat if you have any tech issues, and we'll see if we can help. If you'd like to ask questions on Zoom, please use the Q&A function, not the chat, and you can ask a question anonymously if you wish. On Facebook, please post your comments or your questions in the comments section. If we don't get to your question, we will respond via email or Facebook, depending on how you're joining us today. And a reminder, if this webinar does raise any concerns for you, free counselling is available. You can call Blue Knot on 1800 421 468. Okay. So just a bit of background. The Your Story Disability Legal Support Service is a joint initiative of the National Legal Aid and the National Aboriginal and Torres Strait Islander Legal Service. Over the duration of the Disability Royal Commission, we've supported thousands of people to access free legal support and safely share their stories with the Disability Royal Commission. Since the Royal Commission has finished and they've handed down the report, we're providing ongoing support to people with disability to access legal services. So today we've got three lawyers from the Your Story Disability Legal Support team, Michelle Bowler, Lauren McCauley, and Danny Philippa, who are going to be discuss issues from the report around health, education, employment, and housing. And at the end of the session, we will have a Q&A opportunity for question and answer. So if you do have those questions, please put them up and we'll do our best to answer them. If we're unable to answer them, we'll get in touch with you by email or Facebook, depending on how you've connected with us today. Okay, so first up, we've got Michelle Bowler, who's going to present about health and issues with health out of the Royal Commission. Michelle has been one of the Your Story lawyers for Victoria since 2020. She previously worked at Victoria Legal Aid in the legal help team, giving information and advice over the phone to a range of callers, including prisoners and people affected by natural disasters. Michelle has also worked at several community legal centres. She has 4 young children, including children with disabilities. In her spare time, she teaches yoga and is interested in making yoga accessible and teaching trauma-sensitive yoga. Michelle is completing a Master in Disability and Inclusion. Over to you, Michelle.
Thanks very much, Keith. All right, so I'm going to talk about health. If you could please move to the slide. Thanks, Keith. So I'm going to start with a narrative or case study that I've taken from Volume 6 of the Disability Royal Commission's final report. And the Disability Royal Commission says that these de-identified narratives of an experience that was shared with them in a submission or a private session. For the presentation, I have shortened the narrative a bit, and I've included on the slide just a quote from the narrative I'm about to read. So this is the story of Amaya. Amaya is blind and uses Braille. She grew up in a refugee camp with no access to special education or technology. She told the Royal Commission that she never felt like she had a disability because her father encouraged her to do everything her siblings did. She said, "My family and community were very supportive and actively helped and assisted me to be independent. This made me very capable of living by myself and managing my needs." Amaya came to Australia in her late teens and says that since then she has felt discriminated against. The cultural differences and the isolation in school started to make life stressful. I was more aware, conscious, and anxious about being a blind person. Following school, Amaya started a relationship with a man who had a vision impairment, and they decided to start a family. Their GP referred them to an IVF clinic because there were issues having a baby naturally. Amaya says, "The consultations with the IVF clinic helped her make an informed decision. They had several tests and all the tests came out good. As part of the IVF process, Amaya was able to self-administer hormone injections by listening for the clicks that the injection device would make. She says it would have been easier and safer if the instructions and markings on the device were in Braille. IVF was successful, but Amaya's joy was crushed by people's negative attitudes to her pregnancies. She says that people only saw a blind lady who is pregnant instead of someone who wished to be a mother. I have been discriminated against, judged, and questioned by many people. She said health professionals were the worst. They constantly questioned her capacity, asking if she was physically and mentally prepared to look after the baby. One person demanded to know who was going to stay awake and take care of the baby. I want to be that person. I wanted to be a mother. I wonder if they would ask the same of any parent who is in this situation. When Amaya's baby was born, her partner overheard health professionals discussing whether Amaya would be able to care for the baby. Another asked her partner whether they would be able to cope. Amaya said people often treated them as if they were invisible, talking about their capacity in front of them. Amaya said that instead of feeling harassed and constantly questioned and coming home being anxious about fear of losing her baby, she would have liked practical support. For example, instructions for baby products, medication, and supplies in Braille would have been helpful. Now Amaya's child is a preschooler, and people constantly express their surprise at how well he is cared for. Amaya would like to have more children and hopes people's attitudes will be more positive. I believe I also have the right to be heard, have an opinion, and have the same dignity as any other person." So that's the case study, and I'll come back to that in a little bit. Can I have the next slide, please, Keith? So I'm going to talk a little bit about what the Disability Royal Commission found or heard in relation to health, and then we'll move on to what some of their recommendations are. So they found that people with disability have an equal right to the highest attainable standard of health, but that in reality, they are definitely denied equal access to healthcare. They found that people with disability have worse health outcomes and lower life expectancy. They heard that there are attitudes and practices that limit people with disabilities' access to healthcare. And in particular, people with cognitive disability are subject to systemic neglect in the Australian health system. Next slide, please. So moving on to some of the key recommendations. So as the word key suggests, this is not every single recommendation. We're trying to, I guess, highlight some of the bigger ones. So the Royal Commission has recommended further education and training of health professionals in relation to cognitive disability, develop and implementing a cognitive disability health capability framework. So this would have the core knowledge, skills, and attributes that healthcare providers need in relation to cognitive disability. a review of accreditation standards and curriculum for health professionals to ensure that cognitive disability health content is sufficiently covered. Developing specialised health and mental health services for people with cognitive disability. So they found that access to that combination varies a lot across the country. Next slide, please. Introducing disability health navigators to assist people with cognitive disability and complex health issues to find their way through the health system. Publishing a list of frequently needed adaptations and supports. So, for example, when someone needs visual aids to overcome communication difficulties. So publishing a list to enable people with disability to receive high quality healthcare. And then finally, one of the key recommendations in relation to health is legislating a right of people with disabilities to have equitable access to health services as part of the proposed Australian Disability Rights Act. And this right could also be embedded in national healthcare standards and the Charter of Healthcare Rights. So I'm just going to finish with coming back to some reflections on the case study and how Amaya's experience might have been different if some of these recommendations were in place. So a list of adaptations and supports may have been helpful if it was could access a list of things that were available in Braille. So for example, she talked about baby products and medications. If she'd had access to a disability health navigator, they may have helped her find her way through the system. But I think the big one is education, particularly in relation to this case study, but also other stories that we've heard. So further education of health professionals may have changed the way that Amaya and her partner were treated. So that, as she said, that they, she didn't feel like her capacity was constantly being questioned, and also that was sort of talked about in front of her instead of people talking with her. Thanks, Keith.
Great, thanks, Michelle. Okay, so next up, we have Lauren is going to be talking to us about education. Now, Lauren has been a part of your story since 2022 and is currently the manager of stakeholder relations. She is passionate about First Nations justice issues and disability rights, and has worked at Aboriginal legal services in both Victoria and the Northern Territory. Lauren spent 11 years in Mabuntua, Alice Springs, and during that time she worked on the Aboriginal legal aid response to the Royal Commission into the protection and detention of children in the Northern Territory. In the domestic and family violence sector, and at a statutory oversight body protecting the rights of people receiving treatment in the mental health and disability systems. Thanks, Lauren.
Thanks, Keith. Hi, everyone. I am also going to start with a case study. This is in relation to a client that your story assisted. The client had 2 children at school, one of whom was diagnosed with autism as well as mobility issues. And the client indicated to us that the school wasn't making reasonable adjustments to allow the child to participate fully in school activities. The child was expelled and not allowed back at the school. And they were told that this was because of bad behaviour, but the client believed it was because the school didn't actually want to provide adjustments or accommodate the child. She wanted to pursue a discrimination complaint, but was afraid that the complaint might impact their other child who they were hoping to enrol at that same school. Because of the fear of repercussions in relation to that other child, the client ultimately didn't pursue a discrimination complaint. There's also a second case study that I wanted to discuss. This relates to adjustments and participation in a mainstream school setting. So this was an adolescent boy and his mother that your story assisted with challenges that they were experiencing at his school. The child had numerous diagnosed disabilities and was really well supported by his family and professionals. The team of therapists and specialists had recommended that the school adopt certain measures to assist the child with learning and practicing appropriate social interactions. The school was not following the recommendations, and this meant the child was not getting the support needed to be able to fully participate in the school setting. The relationship between the school and family broke down, and the school began limiting the input that the family and the team of therapists had in discussing the child's needs at school. The family also felt pressured by the school to move their child into a specialist or segregated education setting, which was at odds with their preference for him to be educated in a mainstream setting. Rather than implementing the measures suggested by the child's therapists to build skills around social interactions, the school took a punitive approach and restricted him in terms of the interaction he had with other students. They also failed to respond properly to bullying that he was subjected to. The child did have a personalised learning and support plan in place, but adjustments in that plan were not being implemented consistently. And ultimately, the client's experience was that the school just didn't seem to have any genuine desire to work with the child and his family and his support team to ensure that he had access to education. And I'll come back to those case studies at the end. So people are probably aware that in relation to education, there were some split recommendations between commissioners in terms of what constitutes segregated or specialist education. But for the purpose of this presentation, I'm going to focus on what the commissioners were in agreement about, which was actually a lot of things. So all of the commissioners agreed that many students with disability continue to be denied access to safe, quality and inclusive education. And that mainstream education needs to be transformed to enable more children and young people to be educated in those settings with the supports that they require. The commissioners found that inclusive education looks like specialist expertise to make reasonable adjustments for students with disability and support for them to participate fully in school life, empowering students with disability to be leaders and have a voice, engaging parents and carers in planning and decision-making, building inclusive attitudes and behaviours among parents, students, teachers and school leaders, enhancing workforce capabilities and changing classroom and extracurricular practices. So there was a lot of evidence about gatekeeping in Australian schools in terms of students with disability facing barriers in accessing mainstream schools. And as a way of overcoming that, the Disability Royal Commission made a really significant recommendation around creating a legal entitlement for students with disability to enrol in a local mainstream school, subject only to unjustifiable hardship. They said that a central record should be kept of enrolment refusal and cancellation. They said there should be an independent review process established to enable a parent or supporter to challenge a refusal to enrol a child at school, and also suggested that there should be clear, accessible material for students with disability and their families on their rights, the obligations of schools and the review processes that they may be able to access. In terms of the unjustifiable hardship exception, the DRC said that that term should be given the same meaning that it's given in the Disability Discrimination Act. which involves different considerations. It includes the effect of the disability that the person is experiencing as a consideration. And then it also includes the financial circumstances of the party being asked to make the adjustment and what the estimated amount of expenditure might be for that adjustment to be made. Next slide, thanks, Keith. So the DRC also found that students with disability are far more likely to be suspended than students without disability in government schools in all jurisdictions. They found this is more so for First Nations students with disability, and that suspensions, exclusions, and expulsions often occur in response to what is seen as negative or disobedient behaviour, but could more be correlated with a failure to provide adjustments for children. And so there was a strong recommendation handed down that exclusionary discipline should only be used as an absolute last resort to avert a risk of serious harm to the student, other students, or staff. That steps should be taken before exclusion to ensure individual behaviour plans and reasonable adjustments have been implemented for the student, and that there's been consultation with the student, their family, carers, and supporters. That there should be a robust review or appeals process. That if a child is excluded, they should be ensured access to appropriate educational materials while they are excluded. And then once they're able to return, they should be supported to re-engage with school again. Next slide, thanks, Keith. Thanks. So on adjustments and supports, the DRC found that schools often failed to provide students with disability with adjustments and supports as necessary to access and participate in all aspects of their education. They commented that the concept of a reasonable adjustment under the Disability Discrimination Act and the education standards is either poorly understood or inconsistently applied. And because of that, they made a recommendation around supporting compliance of schools and the understanding of schools in relation to their statutory obligations to provide adjustments for students with disability. Next slide, thanks, Keith. Thanks. There was also quite a bit of discussion about participation in the school community, and specifically discussion about co-location, in the sense that where non-mainstream schools are located close to or co-located with mainstream schools, that there are opportunities for inclusion that will arise. The DRC heard that students with disability are excluded from full participation in school activities, including excursions, sporting events, assemblies, and school camps, and that there's scope for students with disability to feel socially isolated, both in a special education setting and in a mainstream education setting. There was a recommendation that school educational authorities facilitate participation by students at special or segregated schools in educational, cultural, sporting, recreational and celebratory activities with their peers in mainstream schools, as a way of encouraging and arranging regular interchange between those different students. Next slide, thanks, Keith. Thanks. So the DRC also heard that schools fail to support students with disability to transition from school to further education or employment in the open labour market, and that students with disability are often not given access to work experience, careers counselling, or role models and mentors. The DRC recommended that there should be careers guidance and transition support to aid the transition to further education or open employment starting in Year 9, and that students should be provided with opportunities to undertake work experience in open employment aligned with their goals and interests. If we could go to the next slide, thanks. So the DRC found that open and responsive communication between students, their families, supporters, and schools can enhance student outcomes, but that students with disability and their parents are often feeling as though schools are not listening to them, communicating with them, or considering the lived experience of the student and family when critical decisions are being made about the student's education. And so to support better communication, the DRC recommended that policies and guidance for schools should be implemented to clearly outline how and when students and parents can expect to receive information, take part in the school community, and be involved in decisions. And that these policies should also take into account cultural differences and practices of First Nations families, culturally and linguistically diverse communities, and the signing deaf community. Yeah, thanks. There were also issues revealed in terms of complaints processes, and witnesses before the DRC said that they faced multiple barriers when raising concerns about experiences of their children in educational settings. The DRC recommended that independent complaint management officers should be created where they don't exist or expanded where they do exist in all states and territories to help resolve complaints about schools, specifically complaints concerning the treatment of students with disability. That these officers should fulfill various roles, including providing students and parents with information about their rights and options about complaints, conducting conciliations and connecting families with advocacy support where needed, undertaking formal investigations if a complaint is serious or indicates systemic issues, providing support and assistance to refer matters to a regulator or independent oversight body if it hasn't been resolved, and that these new complaint handling duties and standards actually become embedded in disability standards for education. There were other recommendations which could have a really big impact in the school setting as well, which I've outlined here and which we don't have time to discuss in detail today, but I just wanted to particularly draw your attention to recommendation 7.8 regarding the need to embed a human rights approach to inclusive education, including employment targets for people with disability in schools and the employment of skilled and qualified Auslan interpreters in schools. In volume 4 of the DRC final report, there was discussion about establishing a broader Disability Rights Act at a federal level, which would have aspects that would flow through to the school setting and improve the experiences of students with disability at schools, such as the duty to provide interpreters, a duty to provide accessible information, and a standalone duty to make adjustments. Keith, I'm wondering if we could go back to the case study on slide 10 so that I can just briefly reflect on that with some discussion about what might have been different for that family had these recommendations be implemented. So the legal entitlement to enroll at a mainstream school would have had a really big difference for this family, and it would have assisted them in terms of the pressure they might have been feeling from the school for the child to be moved to a specialist setting when their preference was for mainstream education. The improved policies and guidance around communication and relationships between students, families, and schools would have required this school to be more attentive to the wishes and insights from the parents. The improved policies and procedures on reasonable adjustments would have required much greater accountability for the school in terms of adopting the measures that were suggested by the child's therapists. In terms of the restricted interactions that this student had with other students at the school, the principles around inclusive education and co-location and relationships between different schools would have imposed more of a responsibility on the school to ensure full participation in the activities of the school, and also embedding a human rights approach to inclusive education across teachers' careers would have assisted with the receptiveness of the school to these adjustments that were being suggested. Thank you.
Thanks, Lauren. Now I'll just get back to our slides. Okay, so next up we've got Danny, who's going to talk to us about employment out of the Royal Commission. So Danny has been a lawyer at Your Story since 2021, and before that he worked across a range of legal areas at Legal Aid ACT, including mental health, employment, tenancy, debt and discrimination. He is passionate about improving access to legal assistance and doing work that helps those most in need. And Danny is proud to be part of a service that delivers legal support to people in a trauma-informed and holistic way. Thanks, Danny.
Yes, thanks, Heath. Hello, everyone. Thanks so much for your time today. I appreciate that, and also appreciate this is a big report with 6,865 pages. So there's a lot to cover here, and the employment is a big topic as well. So I'm not going to be able to cover everything that the Royal Commission's looked at today. So I want to try and give you a bit of an overview of what the Royal Commission looked at in regards to employment. So the starting place for it is the DRC looked at employment and inclusion in employment as a human right. So it really looked at Article 27 of the Convention on the Rights of People with a Disability, the right for persons with a disability to work on an equal basis with others. This includes the right to the opportunities to gain a living by work freely chosen or accepted in the labour market and work. So that's really going to guide everything that the DRC has heard and the recommendations they made. So the way I'll talk about this today is I'll break it down by a few of the topics which the DRC broke it down by. So the role that government can play in leading the strategic direction, but also active changes to public sector employment. We'll look at the disability employment services, public sector employment, like I said, social procurement. So that's a lot of procurement that the government does, particularly from disability businesses and people with disability as employees, as well as services which are used by employees with a disability. And then some of the regulatory and legislative changes that are proposed. So very, very briefly, before I move on, the DRC looked at a few barriers to work. So they looked at the attitudinal barriers by employers, people's colleagues, people with disabilities themselves. They looked at the physical, environmental barriers. So that could be the very obvious things, access to employment, but also things such as access to IT systems, captioning, programs within workplaces. They looked at organisational barriers, so why people might get stuck at lower levels, not be able to move up through promotions, that kind of a thing. And they also looked at structural barriers more broadly in the economy and heard a lot of stories from people and their experiences with employment. So, like I said, I'll move through each of these slides to try and talk about each of these topics as the DRC spoke about them. If this is an area you're really interested in, because I can't cover it all, really recommend you read volume 7. There's heaps more information there. So if you're interested, dig into that. Keith, if you go to the next slide, that'd be great. Thank you. So the first stage, and this sort of ties into other areas of the Royal Commission's report, it looked at government leadership. So this is also really covered in volume 5 quite a lot as well, but the DRC recommended an update to the Australia's disability strategy and making employment a real key focus. Wanted to make sure that it was a strategy that guides all the states and territories, the federal government and the public and private sectors. This also ties into the proposed Disability Rights Act as well. So making sure that employment is a key focus of that, coming back to that fundamental human right to employment and building that into all of these strategies so it all sort of works together. So I'll get you to go to the next slide, please, Keith. Great. So disability employment services. So I won't spend too much time on this because it can get quite complex, but disability employment services are funded services by the government. There's a government scheme that funds this to employ people. There's a lot of recommendations around this, and we're going to talk about some of the more controversial ones at the end. But the Commission proposes a redesigning of the DES model to have more customised employment rather than a one-size-fits-all, to make it much more inclusive for people, have much more flexible work employment supports. At the moment, they're very much, again, one-size-fits-all and not tailored to different kinds of disability. And they recommended removing the 8 hours per week minimum work capacity. This is because people's capacity can fluctuate. Again, it's about being more flexible, and also there are people who can work less than that but may be able to engage with these services. Disability employment services often employ people with a moderate to severe intellectual disabilities, people with Down syndrome, for example, and a range of other people, and are often in services that are considered lower skilled, a lot of cleaning jobs, manual jobs, warehousing type jobs. And so it's quite a specific area as well. We'll talk a little bit more about that at the end, but it's an area that needs some reform. And a big part of that was the training of staff and DES providers to ensure that it allows people with disabilities greater opportunity for promotion and greater opportunity to I guess, live out their full potential and not just be pigeonholed in quite small areas of work. Sorry, next slide, please, Keith. Thank you. So public sector, excuse me, my apologies. Public sector has been a key focus of the Royal Commission. They want to have very strong recommendations around targets for disability employments in terms of both numbers across the federal and state level, but also the level of promotion and the supports that are there. They want to change the merit-based principles in hiring to value diversity and disability. So it's not just about reasonable adjustments, but saying that people with disability bring something to their work and are of value to the organisation. One of the proposed ideas was an adjustments passport, which is a really great idea, which basically means once you have your adjustments and the things you need, if you move between sections, between departments, maybe even between different public services, your adjustments go with you. You don't have to fight the same fight each time to establish what you need. The system should all flow. If you have, say, for example, adjustments that help you with vision impairment or screen readers, that just goes across. You don't have to get new programs every time you move, that kind of a thing. They want better reporting in the public service, better mandatory minimum accessibility requirements when procuring software and other items. So again, making sure all pieces of software in the public service, all computer programs are accessible for everyone, and making sure that any system that the government buys is accessible both for staff and employees within the public service, but also in the public. They're a huge, huge buyer, the government, so they can have an outsized impact. And this is, I guess, really what the Royal Commission is driving at. It's not explicit in it, but the implication is that a bit like with wages, the private sector follows the public sector and the public sector can really lead. It's an area the government has direct control over, so there should be limited barriers to improving things for people with disability in the public sector, sort of with the idea of, a rising tide lifts all boats. So these targets and supports are a really big part of this, and I think it'd be great if they do some of these things. Finally, one of the recommendations is also Disability Rights Council to sort of coordinate, monitor, assess the reporting that's coming through. Sorry, next slide there, Keith. Thank you. So legislative changes. So changes to the Fair Work Act to define disability, to make sure, basically to define it as it's defined under the DDA, the Disability Discrimination Act, to basically ensure that those definitions are consistent, because at the moment they sort of operate separately. Anyone who's familiar with employment law knows that it can be quite a complex area of law. There's often many layers of legislation operating in tandem. Obviously, with Fair Work, you often have to pick whether you will go down a Fair Work path or go down a discrimination path. And there can be strategic reasons why to pick these. Bringing these two things into alignment, making them consistent, makes a lot of sense, to make sure that those choices that people might make, it makes it a bit easier. So in particular, Section 21A of the Disability Discrimination Act should be amended to expand the factors considered when determining whether a prospective or existing employer would be able to carry out the inherent requirements of a particular role. So at the moment, and we'll talk about this a little bit at the end, the inherent requirements can be a vague thing. It's very heavily contested in the law. So by making it a bit more explicit, so what nature and extent of any adjustments did the employer look at? What was the extent of consultation about those things? And how much did the employer do? So it just clarifies an area that can be a bit vague. So I'll just go to the last. So other proposed changes, just before I go on, sorry, I found this photo of this gentleman whilst I was doing some preparation for it. It's not relevant to the slide, but he brought me a lot of joy and, I don't know, a lot of motivation. So I just wanted to share him with you all. Just, sorry, side note. So the other proposed, there was a bit of controversial disagreement between some of the commissioners. So some of the recommendations here were a transition from DES, so disability, that system, to open employment. So one of the key things that were proposed was having a inclusive open employment first. So not just assuming that people would be in specific supported things, but in the open market. There's also sub-minimum wages. So a lot of people are currently paid well below the minimum wage in these disability enterprises and disability employment spaces. So raising those and end this segregated employment by 2034. There's a split recommendation. It's not all the Royal Commissioners fully agreed with this. There's also quite a split in the community. So different communities disagree with some of these recommendations, and there's debate around this. But they do want the sort of, by 2034, changes to lift sub-minimum wages, changes to open disability employment for people. I don't know if I've got another slide after this. Sorry, Keith. So look, just conscious of time, just a bit of a case study to bring some of this together that I have in my experience of working with people with disability. I had a client who was a young autistic employee, was terminated for not being able to fulfill the inherent requirements of his job. Going back to some of the things I was talking about earlier with some of the legislative reform, if these reforms had been in place, it would be a lot clearer when making a claim that he had been discriminated against through this termination. It would be a lot clearer and easier to establish exactly what reasonable adjustments had been considered, what steps did that employer take, was there correct consultation, and make it a lot easier, both for employers, hopefully in a preventative sense, to think, oh, okay, well, these are the steps we have to take to make sure we don't discriminate. But also if there is a case where it's looking to a discrimination claim, a person with disability can make a claim easier and clearer without having to basically jump through very complex legal tests and try and establish things. The law can be a lot clearer. So that would be great if that had been in the case. I think, Keith, that's the end of my section, I believe.
That's your last slide you've got there, Danny.
Right.
Thanks for that. We may come back to you with some questions at the end, but thanks for that presentation. Next up, we have Lauren again, who's going to talk to us about housing.
Thanks, Keith. I'm going to start off with a case study again in relation to housing. And this case study is from the Disability Royal Commission's final report. It's in relation to a woman known as Bronte, who was in her mid-50s at the time she shared this experience with the DRC. When she was in a car accident in her late teens, she acquired a brain injury. Soon after, she ended up in a relationship with a violent man who regularly assaulted her and threatened her children. She eventually received compensation about 10 years after the car accident, and her husband took all of the money and left her. She was left in poverty with limited housing options, and she and her kids ended up living in the garage of a neighbour temporarily. After some time, she was able to access public housing, but she found the house was filthy, dusty, and had holes in the walls. She wanted to complain about the state of the house, but was finding it hard to make a complaint and advocate for herself. She was quite self-conscious about her paperwork and felt as though it looked as though a child had completed it. She told the Disability Royal Commission that if someone ever came to fix something in the house, she would be charged for the repairs and maintenance, even if they hadn't actually fixed the problem. Her daughter moved out of the house because it was in such a poor condition and she felt that it was making her ill. And Bronte believed her life and her daughter's life would have been better if she had somebody who could help, somebody for brain injury people or disability, was what she said. But instead, she felt that people were taking advantage of her because of her brain injury. And there are some really powerful words from her on the slide there, direct quotes that she shared with the DRC about her experiences. So the DRC talked about access to alternative housing options. If we would go to the next slide. Thanks, Keith. Thanks. They heard that group homes can fail to keep people with disabilities safe. They can deny choice and control and deny opportunities to develop and build capacity. That there's a need to make alternative housing options available. Otherwise, people with disability may end up with little to no choice but to live in a group home. So the DRC made a recommendation about improving access to alternative housing options, and they said it was something that could be improved in different ways, including that the NDIA and federal and state governments should work together to expand alternative housing options and support for people with disability to access and transition to other options. They recommended reforming NDIS participant funding models to provide more flexibility about housing, that there should be clear and supportive transition pathways formed for residents, including individual transition plans and access to independent advocacy and a support coordinator to facilitate transition to alternative housing. Next slide, thanks, Keith. So they also thought that housing accessibility could be improved through better harnessing existing Australian building codes to better cater to the needs of people with disability. So they recommended that adopting the livable housing design standards for new dwellings would ensure future flexibility and the adaptiveness of a home. This could also include homes that need fewer or more affordable modifications that would be better suited to the needs of people with disability and integrating their particular environmental needs. They recommended that social housing operational policy and processes should also be improved to include screening for disability during an application process and accessible resources about housing and modification policies, including who's responsible for organising and funding modifications, expected timeframes, and how someone can follow up and raise concerns. Next slide, thanks, Keith. They recommended that tenancy and occupancy protections should be increased through legislation and regulations. For tenancies, they said that no grounds termination rights should be replaced with reasonable grounds termination rights, and that all states and territories should pass legislation requiring landlords of private sector premises to demonstrate a good reason for terminating any tenancy of residential accommodation. In both social housing and private tenancies, they said that tribunals should have power to take into account whether a tenant or co-tenant has a disability and the nature of that disability in determining whether it is just or reasonable to make an order for possession of the premises. They also recommended that all states and territories should adopt the provisions of the Victorian Residential Tenancies Act as set out in 12A to protect the rights of all residents of specialist disability accommodation under the NDIS. Section 12A is really extensive and would include like a suite of protections that would really improve the position of people in this circumstance. It includes a formal residency agreement. It would include minimum notice requirements in relation to any rent increases and any change in the status of a provider's registration. It would include an obligation on providers to explain notices and information to residents in a way that they are likely to understand. And if it appears that further support is needed, a duty to give notice or information to a family member, advocate, or support person so that they could assist the resident in understanding and acting on that information. They made recommendations about occupancy principles because of the finding that residents of boarding or rooming houses have far less rights than tenants. In New South Wales, the rights and obligations of a proprietor and resident of a boarding house are governed by occupancy principles, and essentially they recommended that that should be mirrored in other states and territories. Occupancy principles would include a resident's right to know the rules of a boarding house before moving in and a right not to be evicted without reasonable written notice. They also recommended that tribunals should have jurisdiction to resolve disputes arising in boarding or rooming houses, particularly around eviction. And again, that tribunals should be required to consider an occupant's disability, the nature of that disability, and really importantly, the likelihood of that person finding alternative suitable accommodation. To improve safety in supported residential services, the DRC recommended that minimum service standards be established for all supported residential services, that there be monitoring and oversight of this, and that regulatory bodies be given adequate powers to enforce all of these standards. The minimum standards would be really extensive, but key things they would include are the development of support plans for each resident, which would cover personal care, financial management, medication management, and the use of restrictive practices, maintaining up-to-date records, having clear complaint management processes, guaranteed access to independent advocacy services and community visitor schemes, a central registration of all supported residential services and their equivalents, and procedures to monitor services in response to complaints about them. The Disability Royal Commission also made some broader recommendations at a policy level as to how homelessness amongst people with disability could be prevented and responded to. They recommended that the Australian government and all state and territory governments commit to a policy of no leaving into homelessness for people with disability. That would include establishing and nominating a lead agency with responsibility for planning and coordinating the transition of people away from service or institutional settings directly into safe and appropriate housing. And insofar as policies at a national level are concerned, they essentially recommended that there be more cohesion between the separate policies that relate to housing and homelessness and people with disability. Keith, if we could go back to the case study, because I briefly just wanted to return to that at slide 29. So the experience of Bronte would be improved in various ways. Were the recommendations implemented? She would have had advocacy support in terms of housing options, how to secure housing, and how to raise complaints. There also would have been clearer information about processes for repairs and maintenance, costs, and the responsibilities of the landlord in terms of upkeep, which would have had a big impact on her situation. Thank you.
Thanks, Lauren. Now, where we're running fairly short of time, but I wonder if I could, Danny, if you're available, I wonder if you could put to you a question that's come through. And it's just, so the question's asking about, in terms of employment, do the recommendations cover discrimination in the employment context? And is there a focus at state level?
Yeah, so as I said, the main focus of the recommendations was around the inconsistencies between the DDA and the Fair Work Act. There isn't much in terms of focusing at a state level at this stage. So it's mainly around the changes, legislatively speaking, are mainly around the Fair Work Act. In terms of more broadly, what the Royal Commission looked at was trying to reduce incidents of discrimination and improving outcomes for employment for people. So to avoid a lot of these things. So it's less about treating the outcome, as it were, but more about trying to say, well, how can we improve people's experience of employment? So through the changes to the public sector, through changes to the disability employment services, trying to make sure that people's experiences of employment are more inclusive, have better opportunities for employment, but better opportunities within employment for promotion and better outcomes. So that's really the big focus, a lot of the recommendations in the report.
All right, thanks, Teddy. And if I could maybe throw a quick question to Michelle as well, if we've got time. Are you available? Are you there, Michelle?
Yep.
Okay, just a question about what are the major legislative change implications coming out of the Royal Commission?
No problem. So as you would expect, and Danny talked about how big the report is and how many recommendations there are, a lot of that is about law reform. So I thought I'd give you just a couple of examples. One is an expanded definition of domestic and family violence. So this would be amending state and territory domestic and family violence laws and definitions so that there's a disability inclusive definition of domestic violence that includes things like all relationships in which a person with a disability might experience violence. So that would include carer and support worker relationships. Also having a definition of domestic or family violence that includes disability-based violence and abuse, and extending the definition to all domestic settings. So that could be things like group homes and respite centres and boarding houses. And another big law reform is the proposed Disability Rights Act. If that was enacted, the plan is that there would be remedies you could take to through the federal court, but also that there'd be equivalent legislation in every state and territory. And if the Disability Rights Act came to be, then it would create duties of equality, accessibility, inclusion, consultation and accountability for public authorities. So they're just a couple of examples of where we see law reform. Thanks, Keith.
Thanks, Michelle. Now it looks like we've unfortunately run out of time to field further questions. As I mentioned at the beginning, though, if there's outstanding questions that you've put forward, we'll try and answer those by email or by Facebook as appropriate. So I'd just like to wrap up by thanking our presenters, Lauren, Michelle and Danny, and also thanks to our interpreters, Carolyn and Erin, and to our captioner, Teresa. We'd love to hear from you, so please complete the survey that'll pop up at the end of when this webinar ends, and we'll share the survey in the chat as well and on the Facebook stream. So a recording of this webinar will be available on the Your Story Facebook page if you'd like to revisit any of the points that have been discussed, and it will also be up on YouTube in coming weeks. And a reminder that if you have if this webinar has raised any issues or concerns for you, counselling is available free of charge from Blue Knot on 1300 657 380, and I believe that number is up in the chat and will also be on Facebook. Okay, so thank you for joining us today, and we'll sign off there.